Welcome to Talking Business, your straight-talking guide to dealing with corporate matters. Whether you are a private or public company, an owner-managed business or an entrepreneur, a director, company secretary or in-house counsel, this is the podcast for you. My name is Sophie Brooks and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Each month, I'll provide an update on the latest developments that matter to you, and we'll be joined by an expert to take a deep dive into a key corporate law topic. Okay, this month we've got yet another case to do with the timing of dividend payments. We've got an update on the Register of Overseas Entities holding UK land, and then I thought we'd have a look ahead to some major changes that are on the horizon for UK companies under the Economic Crime and Transparency Bill, which is currently working its way through Parliament. So first up then, following on actually from last month's case, last month you might remember we looked at a case that was to do with the timing of the payment of an interim dividend. Well, this month, like buses, we've got another one where the court in this case had to consider the timing of a dividend payment, again to determine whether or not that dividend was actually lawful. So this case involved a number of director shareholders in a company, so that the directors and the shareholders are the same people. And those director shareholders owed money to that company, and that was noted on their directors' loan accounts. So in July 2016, they decided to declare a dividend, and they wanted to backdate it to July 2015. And then they wanted to use that dividend basically to reduce the amounts owing on the loan accounts at that time. So the company's accountants recorded the dividend payment in the company's accounting system, but not until April 2017. And when the accountant did that in April 2017, they reflected that the dividend was made actually in July 2015, so that kind of backdated date. The company then went into administration, and the question arose as to when the dividend had actually been made. So was it July 2016 when the directors decided to declare the dividend? Was it April 2017 when the accountants made the entry in the books? Or was it July 2015, which was the backdated date that the directors and the accountants used? The crucial thing here was that if the dividend hadn't actually been made until April 2017, when the accountants put it in the books, then it would have been unlawful because of the company's insolvency at that time. So in this case, the court held that the relevant date was the date that the directors had declared the dividend, so that July 2016 date. And on that basis, actually, the dividend was lawful. So dividends are a type of distribution at law under the Companies Act. And the court looked at that definition of distribution and said it requires a positive action which affects the company's finances in some definite way. And the positive action in this case was the decision in 2016, not just to declare the dividend, but also to allocate it to the directors' loan accounts. And that action was recorded in the 2014-2015 accounts. The fact that the dividend wasn't actually recorded in the company's internal accounting system until April 2017 was actually irrelevant. Because at that point, the court said, well, actually, all that's happening there is that the company's accountant is just updating the internal records to reflect the fact that a dividend had actually been made in 2016, so that date when the directors resolved to make that dividend. So in legal terms, the director shareholders had declared an interim dividend and then had agreed, in their capacity as shareholders, that the dividend would be paid into their directors' loan account. And the court found that if a dividend was genuinely allocated by director shareholders to reduce that director's loans, and that was recorded in the company's accounts, then that payment would amount to a distribution under the Companies Act without there being any further action and irrespective of the legal effect of their actions. So when we're thinking about this and thinking about directors' duties, directors' requirements, directors have to keep a record of any money that they borrow from or that they pay into a company, and that's usually known as their director's loan account. And the company's account should also show all money withdrawn from the company and all money paid back between the company and those directors. And as this case illustrates, it is possible for directors who are shareholders to offset their loan accounts by declaring a dividend, which then reduces the amount outstanding on those accounts. As always, the declaration and payment of that dividend has to comply with the law relating to distributions, and it's only going to be possible if there are sufficient distributable profits within the company at the relevant time. So dividends have to be paid out of realised profits that are available for distribution. So what should directors be doing? Well, obviously, they should ensure that they have clear records about the timing of any distribution. And that's particularly in relation to the date that the distribution is made, as opposed to necessarily when the directors resolve to approve it. And that can have really important consequences, including in relation to tax. I'm saying, appropriate records have to be kept, but particular care should be taken, I think, when a distribution is being settled in some way other than in cash, for example, like we had in this case, by setting off a debt. And those records need to very clearly show when the distribution was approved. Usually that's going to be by a board resolution or maybe a shareholder resolution. And also when and how that distribution was made. And clearly, accounting records, both internal and in relation to formal accounts, are going to be pretty fundamental in relation to that kind of evidence there. So moving on then, the end of just last month, 31st of January, was the deadline for overseas entities that hold land in the UK to register at Companies House. And yet, apparently, only about 10,000 out of an estimated 31,500 eligible overseas entities have actually done this. So only about a third of all the companies that should have registered have actually done so. So this was a requirement that was introduced back in August 2022, last year. And it's the Register of Overseas Entities. That's what it's known as. So although it came in on the 1st of August 2022, overseas entities that already owned or leased UK land at that date were given a 6-month transitional period to register with Companies House and, crucially, give details of their beneficial owners. So it's that 6-month transitional period that has just ended at the end of January. So when we're talking about beneficial owners here, for those of you that are familiar with the PSC regime, the regime of persons with significant control over companies, it's very similar. That's a very similar regime that's been introduced in relation to this register of overseas entities. So when we're looking at an overseas entity, a beneficial owner is going to be a person or a legal entity that holds more than 25% of the shares or voting rights in that overseas entity, that has the right to appoint or remove a majority of the board of directors of the overseas entity, or that exercises significant influence or control over the overseas entity or over a trust or firm which itself meets one of those conditions. So if more than 25% of the shares in an overseas entity are held by a trust, you would also have to register as a beneficial owner of that underlying overseas entity anybody else that exercises significant influence or control over that trust. So obviously this is all about transparency, trying to get to the bottom of who actually holds land in the UK. So overseas entities have to take steps to identify their beneficial owners and gather the information that has to then be registered at Companies House in relation to those beneficial owners. So as I mentioned, there was this transitional period for existing entities that already held UK land, but actually the registration requirements applied from the 5th of September 2022 in relation to new acquisitions after that date. So any overseas entity that acquired UK land from the 5th of September last year onwards had to register at Companies House and provide details of its beneficial owners before applying to the land registry for that transaction to be registered. So, as I say, overseas entities have this obligation to investigate and take steps to identify their beneficial owners. They then have to verify that information. So the information about the overseas entity and its beneficial owners that's filed at Companies House has to be verified by a UK regulated agent. So that's basically a person or organisation based in the UK that is supervised for the purposes of the money laundering regulation. So things like a credit institution, an auditor, accountant, company service provider, that kind of thing. The agent itself actually must have already registered with Companies House and obtained what's called an agent assurance code. And then each time the agent files the information at Companies House, it has to provide that particular code. And the agent has to verify all the relevant information based on documents or information that it's obtained from a reliable source which is independent of the person whose identity is being verified. So you can't just take the information supplied by a beneficial owner. You've got to go and independently verify that information and make sure that it's all correct. Handily, the Land Registry has actually issued a list of UK regulated agents who've got that crucial agent assurance code and can complete the required verification checks on behalf of the entity and file that at Companies House. So what if you don't do it? So what about, I said earlier, only about a third of the overseas entities required to register or that we think are eligible for registration have actually done that. Well, what's the consequences of not doing that? Well, overseas entities that have missed that 31st of January registration deadline will now find that, in fact, they are unable to sell or transfer or lease or charge the land that they hold. The Land Registry is going to place, or will already have placed, a restriction on the title register of the relevant land, and that's not going to be lifted until the overseas entity has complied with its registration requirements and has in fact obtained an overseas entity registration number from Companies House. And not only are they going to be unable to deal with that land, but also by failing to register, both the overseas entity itself and all of its officers are going to be guilty of a criminal offence, and that will be punishable by a prison sentence and or a fine. So, obviously, overseas entities that have not yet registered at Companies House should do so as soon as possible. They need to investigate and identify their beneficial owners and engage the services of a UK regulated agent to help them verify that information. They can't just file it directly themselves. There is this third party step of verifying that the information that has been provided is correct. And what about sort of the other side? What about if you're a person who is dealing with an overseas entity that holds UK land? Maybe you're a purchaser that's acquiring a UK group where the land is held in an offshore company, or you're a lender taking security over UK land that's held by an overseas entity. How is this going to affect your transaction? Well, you should be asking for confirmation of the overseas entity's identification number before you proceed with that transaction. And if the entity is unable to provide that, then the third party, you should insist that the registration takes place before completion. Okay, so finally, I mentioned that there are some pretty significant changes on the horizon now, thanks to the Economic Crime and Corporate Transparency Bill that is making its way through Parliament. We think it's going to become law. It's going to receive royal assent sometime in spring 2023. So again, like the Register of Overseas Entities that I just talked about, this bill is all part of the government's drive towards transparency and accountability, introducing some pretty wide-ranging reforms actually to tackle economic crime and understand actually who owns and controls UK corporate entities. So the bill contains various proposals in a number of different areas, but I'm going to focus on just a couple of them today. The first one, I would say, is probably going to be the most sort of significant one for us in practice, I think, and that's the introduction of compulsory identity verification procedures for all new and existing company directors, and also all company PSCs, so those people I mentioned earlier, so the people with significant control over companies. And also, it's not just the directors and the PSCs themselves, but also anybody who files information at Companies House. So typically that tends to be done by lawyers, accountants, auditors. So they're all going to have to go through this new verification procedure. Like with the Overseas Entities Register, there's probably going to be a transitional period for existing companies. So eventually, we don't know quite when, but probably later this year, the provisions will come into force, and then there'll be a transitional period within which existing companies are going to have to comply with these new verification requirements, and failing to comply within that transitional period will then be probably a criminal offence and result in fines as well. So for directors of a new company, they're going to have to complete the identity verification procedure before applying to the registrar to form that company. And then post incorporation, a new director must verify their identity before the appointment is notified to the registrar. So if you've got an existing company, you want to appoint a new director, you're going to have to, that director is going to have to verify their identity before their appointment will actually take effect. Companies themselves will also have to ensure that an individual doesn't actually act as a director of the company unless their identity has been verified. So again, trying to introduce some checks and balances there to stop people acting as directors of a company unless they have verified their identity and proved that to Companies House. PSCs, people with significant control, they're going to be required to verify their identity and then maintain that verified status as long as they're registered at Companies House. And similarly, what's known as an RLE, a relevant legal entity, which is effectively where you've got a PSC, so a person of significant control, but that person is a legal entity, a company. So if you've got a company that meets the PSC conditions, then they're also going to have to appoint an individual who's going to be their registered officer and arrange for the identity of that registered officer to be verified. So you can't hide behind that layer of corporate identity in your beneficial owner chain there. In relation to sort of the method of verification, well, that you're going to be able to either do that directly with Companies House or go through an authorised corporate service provider. So that's going to be somebody like a lawyer, an accountant, a company services provider, and they're going to have registered themselves at Companies House. If you verify directly with Companies House, then that apparently is going to be mainly via a digital service that will link a person with their primary identity document, so something like a passport or a driving license. But we are waiting really for the finer detail of the procedure for identity verification. That's going to be set out in some secondary regulations, which we haven't yet seen. And also the actual start date, we don't know when that is. As I say, there will be a transitional period, and we've got to allow time for Companies House to get their new processes up and running. I'm sure they're working frantically behind the scenes to get that up to date, but we don't actually have any clarity just yet on when all of this is going to come into force. So, in addition to introducing identity verification requirements, the bill also contains various other provisions relating to directors. So, these include things like an individual won't be able to act as a director if they're subject to UK sanctions. And also that persistent failure to comply with filing or identity verification requirements, they're now going to become grounds for disqualification as a director. And as for corporate directors, so the government has confirmed that the powers that it's actually already got and that were granted to it back in 2015, actually, to restrict the use of corporate directors are finally going to be brought into force. So, in order for a company to act as a director of another company, the corporate director must itself have all individual directors whose identities have all been verified. So again, we're just trying to stop companies using layers of corporate identity in order to hide the identities of the individuals that are actually behind the ownership and control of those particular companies. So I think identity verification, that's probably going to be the biggest change that this bill, the Economic Crime and Corporate Transparency Bill, is going to introduce. But there are some other measures, again, all aimed at reducing the misuse of companies and increasing their transparency. So some of the other things that are on the horizon, things like new restrictions on company and business names, and as well, actually, the power for the government to order a company to change its name in some circumstances. All companies are going to have to maintain a registered statutory email address for the first time, although that's not actually going to be visible on the public register, but it will be available behind the scenes for government agencies. And then in relation to a company's statutory books, so if you're a company secretary or a director within a company, you might be aware, hopefully you're aware, of the requirement for a company to maintain various different registers. So, for example, a register of directors, a register of directors' residential addresses, register of the PSCs that I mentioned, persons with significant control. So, one of the things the Act is going to do, this new bill is going to do, is require all of those records to be kept centrally at Companies House. So basically, at the moment, there's sort of a duplication of effort because the company maintains those records internally, but also files the relevant information at Companies House, and that information is kept at Companies House. So what the Act is going to do when it comes into force is say, well, all of that information now, you don't keep that internally in the company, your register at Companies House, and that is your record, your sort of single source of truth, if you like, in relation to those particular registers. So that's some stuff in relation to companies. I just thought I'd briefly mention before we finish one other area of reform under the Economic Crime and Transparency Bill. So this relates to UK limited partnerships. So these are the most sort of common situation in which we come across them is in relation to institutional private fund structures. But again, there have been concerns that they are effectively being misused, and therefore the bill introduces various proposals in relation to these limited partnerships. So that's things like a requirement for all UK limited partnerships to submit more detailed information about who their limited partners are, and also to submit details of their general partner's registered officer and named contact, where that general partner is a legal entity. So again, you can't hide behind another corporate. We're going to look through that and try and see who is actually the person registered behind that legal entity. There's also going to be a requirement for all UK limited partnerships to maintain a registered office in the part of the UK in which they're registered, even if actually their principal place of business is outside the UK. They're still going to have a link and an office in the UK. There's going to be greater powers for HMRC to demand audited accounts for a limited partnership to be filed. And then finally, powers for Companies House to dissolve a limited partnership if it believes that the limited partnership is no longer active. So, as I say, quite a lot of changes on the horizon there for both limited partnerships, but also primarily for UK companies. Also, all of the identity verification requirements that I've been talking about in relation to directors of companies, there are also going to be regulations that will apply the similar kind of requirements to members of LLPs, so limited liability partnerships, which, although they've got the word partnership in their title, actually it helps to think of them as being a little bit more like a company. So again, members of LLPs are going to be subject to these additional requirements. So they're quite significant, really, and they're going to involve some changes to internal administration of companies, certainly internal changes to how we deal with Companies House. As I say, we don't know exactly when the changes are going to come into force. The bill is likely to receive royal assent sometime in the spring, and then I think there will be a period where we start to see these secondary regulations fleshing out the detail of the requirements and the actual regulations coming into force probably later this year, maybe even tipping over into the following year. That's it for this month. Hope you found that interesting, and I'll see you next time. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.